So here's where we're at, Mr. Allen. So, I think, it seems like Mr. Allen doesn't want you to speak, ma'am, but who is this?
That's my mother.
Your name? That's
And
okay,
what
that's
is it
okay.
you want me to know about this?
Tracy Allen, his mom.
Okay,
Is raised. Detention, house arrest is a form of confinement, is a legal restriction. Home detention that keeps you at home with specific expectation, often using electronic monitoring as a condition of that probation. It wasn't titled as house arrest. However, if you look at the referral form, it's in a box which refers to house arrest. In that is the electronic monitor with a curfew. So he's on a hybrid. I think it's fair to say that he is supposed to be in his home or in that residence during those restricted hours. He's permitted to be outside of that during the other hours. So it is a hybrid, but it's still home incarceration or home detention for that purpose. Electronic monitoring, a person on electronic monitoring after conviction can be charged with escape if the electronic monitor is imposed as part of the criminal sentence or community control sanction. The case law bears this out. I think if you read the statute on its face, you have those same questions that are raised by the court as well as the parties in this case. However, the case law bears it out in State v. Sutton that a person that is on electronic monitor is, for all intents and purposes, under detention. They're under the restrictions. They're under the restrictions of this court's probation department in this court. The paper trail that we have presented to the court, the electronic monitoring work release referral form, as I referred to that under electronic monitoring supervision, there's a box for UMHA, there's a box for curfew. And if you recall, the departments have to approve a residence. So there has to be a residence, it has to be, the specific terms are delineated in the document itself. So that is where he is supposed to be. And for all intents and purposes, this is detention.
but the EMHA box is not checked.
Correct.
Right?
Correct, but as I said, the second box is the restriction, the electron, he has that electronic monitor on him. He is restricted in his movement. He is supposed to be in the residence during the period of 8 p.m. to 8 a.m. So for all intents and purposes, he is under detention. The consent form, which was also presented to the court for placement on the monitor, he consented to be on this. He went through the rules with Officer Wilson. Officer Wilson had indicated he read him the rules verbatim in page 4 of this. This is the particular unit that he was on. It indicates on page 3 that you must reside in a residence where mail can be received. If you're not the property owner or lessee, holder, a resident, must be completed showing approval for occupancy. So that was done in this case. The consent form for placement onto the monitor on page 4, there are a couple of bullet points there as well. You are not to remove your monitor without authorization, cut, destroy, etc., and you are responsible for any intentional damage, destruction, and or loss of monitoring equipment. So Mr. Allen was put on notice of these things. He signed this form at the bottom. It was dated on the 11th, and as we know, the monitor was removed 2 days later. It was never recovered, and there was a loss to Community Corrections, which they're responsible for a little short of $2,500, thus making that a felony as well. Your Honor, the state believes we have presented a case beyond a reasonable doubt that this defendant did commit the offense of escape as well as the offense of theft, and we'd ask you to make a finding of guilty as to both counts.
Mr. Elter?
Thank you, Your Honor. Your Honor, this case really comes down to correctly applying the statutes that are in play. And obviously the main one is 2921 34, the escape statute, which states very clearly at the beginning, no person, knowing the person is under detention. That's the key to the whole case, Your Honor. The state has presented its evidence showing all of the documents and all the procedures and all the rules and regulations that they put someone that is going to be on electronic monitoring forward. In none of those documents does it state that you're under detention, doesn't even state you're under confinement. The form that they use for the referral, as you just noticed, Your Honor, has an easy spot to put electronic house arrest. That's what that stands for. Then they have curfew. But the problem with the curfew is it doesn't define what curfew is, what it constitutes in terms of detention, what the penalties are for breaking curfew, what specifically can happen, and what constitutes breaking curfew. Additionally, it doesn't inform the defendant that if you do tamper or monitor with your box, you're going to be charged with felony theft, when really it seems most appropriately if the device is damaged or lost, criminal damaging would be one of the components, since the officer testified that they were able to ping it. She thought it was down in a sewer potentially, but couldn't locate it. The whole crux of it comes that Mr. Allen didn't have the information that he should have had to understand what his requirements were, the parameters that were put upon him, and the specific penalties. And another thing in terms of him being charged with F3 escape.
Well, for the knowingly element, though, Mr. Elter, I mean, he needs to know that his conduct will probably be of a certain nature or result in a certain outcome, right? I mean, he doesn't have to know all the ins and outs of the laws of detention. He just needs to know that if he cuts that monitor off, he's not subject to the jurisdiction or the supervision of the court anymore, right?
Correct, Your Honor. However, I think though I think it's one thing to cut a monitor off and be charged with criminal damaging, which seems to be a likely flow of what happens there, potentially a supervision issue. To be charged with this felony escape and face prison time, and then also be charged with felony theft and additionally face prison time, when the underlying charge was an F5 without any criminal aspects or without any violent aspects to any of his behavior, I think that the jump in penalty is significant enough that the defendant needs to be very clear of the ramifications that occur for simply cutting the monitor off. As we know, Your Honor.
But it's pretty clear based from the evidence, Mr. Elter, that he knows that from 8 o'clock p.m. to 8 o'clock a.m., he has to be at home. I mean, that's very clear in the rules and also the explanation from Officer Wilson, right?
I believe so, Your Honor, but I also think that it needs to be explained to him that if he's not there for curfew, it's different than you're going to get a detention or you're going to get a demerit.
I'm sorry for interrupting. Go ahead.
And that's actually my point, Your Honor. I think that the penalties and the results are so significant that if we're going to spell out very clearly what you can and cannot do with the device itself, it should at least be spelled out that you could be subject to these penalties that he's facing. I don't think that the prosecution has been able to prove that he knowingly was under detention. He knew he had the bracelet on, Your Honor. He knew he had curfew, but he wasn't knowingly in detention in that he was in a facility, that he was in a lockdown premises, or that he was in some sort of treatment facility that would release him and then he had to return to that facility. That's my point, Your Honor, and I think that based on that, the components of escape are now here regarding detention, and additionally, the penalties that were there in terms of him not being apprised of those are critical in terms of any decisions that reflect upon him breaking detention. And I also would add, Your Honor, the fact that the address where this is presumed to occur, the violation is in fact in Hamilton County. And I think there is a question whether or not the violation could be brought here as a charge in the first place regarding that, Your Honor. But I think the biggest component here is the person has to know that they're under detention. And I think that that's the biggest problem here, and I don't think that the state has proven that beyond a reasonable doubt. Thank you, Your Honor.
Mr. Harris, anything else I need to know about this?
Just briefly, Your Honor. We've all heard this over the years about ignorance of the law is no excuse. We can't get into the mind of the defendant, but I can't help but believe somebody placed on an electronic monitor with certain rules, especially as to movement and where you're supposed to be during certain periods of time, somehow doesn't know that they're not under detention. This defendant had been placed on community control, was under a sentence, was ordered by this court in a violation hearing to be under electronic monitor with a curfew. It's the state's position that does constitute detention for that purpose, and reasoning and common sense bear that out as well. And as far as that is concerned, as I said, this court ordered it, the probation department enforced it, community corrections was monitoring it. He, for all intents and purposes, was under the jurisdiction of this court as well. And again, to make an argument that of ignorance, that, well, I didn't know anything would happen if I just cut this monitor and just take off, which is what this defendant did. His whereabouts were unknown for those 7 days until he was found in the Hamilton County Justice Center. We would ask again that you return a verdict of guilty as to both counts.
So with regard to the escape, I think the essential elements are that the defendant was under detention, that he knew he was under detention, that he purposely broke that detention, or he failed to return following a temporary leave for a limited period, and that he'd been previously convicted of a felony of the 5th degree. I think the issue in my mind, Mr. Allen, is this question of detention, and I don't think, as Mr. Harris referred to it as a hybrid, the supervision, I think we may be able to have an argument as to whether or not electronically monitored supervision, sort of like on an open schedule, would constitute detention. But I do think that you knew that you were supposed to be home at night from 8 o'clock p.m. to 8 o'clock a.m. And I do think that you cut this monitor off. And I think that means that you broke the detention and that you failed to return following the curfew period. You did know that you were under detention, and I think that the electronically monitored supervision with the house arrest, curfew, etc., does constitute detention, and that you were convicted of a felony of the 5th degree. I find that the state has met all of the elements of the escape charge beyond a reasonable doubt, so I am going to find you guilty of escape. The theft charge seems to be a bit of a stretch to me, but the essential elements are that you did exert control over property beyond the express or implied consent, and that the value was in excess of $1,000, even though we didn't really talk about it too much during the case. The court does find that the state has been able to prove all of those elements beyond a reasonable doubt. So I am going to find you guilty also of the charge of theft. I also find in the, I don't have my docket in front of me. Here it is, 24 CR 42-183 case, that you have violated the terms of your community control. Probably makes sense to set this for a final violation hearing and a sentencing in a couple of weeks, or are we ready to go forward with sentence today?
I think Mr. Allen would like his sentencing today.
Okay. We do need an updated jail time credit figure, and I don't know if we can get that from Officer Fisher. She was a witness in the case, but why don't we take a break and come back at 11 for sentencing? Does that work for everybody?
Yes, Your Honor.
All right, so we'll come back at 11 for sentencing, and we can get Officer Fisher, if she's still here, back, and that'll give her time to get us a jail time credit figure. I'm assuming that Officer Conroy doesn't have that figure available.
I do not, but I can track her down.
Okay, we'll get it. All right, we'll see everybody back here at 11.
I'll go track her down.
All right, we are back on the record in the Allen case, 24 CR 42183 and 25 CR 42926. Anything, well, first of all, any reason that we should not go forward with sentence today?
No, Your Honor.
No, Your Honor.
All right, Mr. Harris, on behalf of the state.
Your Honor, Mr. Allen has 214 days of jail time credit that should be applied, I believe, to the 2024 case. Your Honor, the defendant was granted opportunities to be on community control initially in his case in 2024. He violated that soon thereafter. The court granted him another opportunity to be out in the community under electronic monitor. That lasted for a period of 2 days. Under the circumstances, I think the defendant's proven he's not amenable to community control, and we would ask to impose a prison sentence. As far as restitution is concerned, a couple of the pieces of equipment were turned in today. So restitution would be $2,099. That's just for the monitor that was not recovered. And I think that's the only deviance from, that was our last state's Exhibit 8, which was requesting more than that. But Officer Wilson came down and plugged up the equipment. It does work. So we are taking that off as far as the restitution request.
So I'm looking at Exhibit 8. We have the charger and the recharger, both were returned. So we have the restitution being $2,099.
Correct.
Okay. Officer Conroy, anything from Community Corrections?
No, Your Honor.
Officer Fisher?
Nothing further, Your Honor.
Mr. Elter?
Speaking with Mr. Allen throughout the process of this case, what led to the ankle monitor being removed was he had a drug habit. And that's actually what happened this exact day when this monitor came off, was he was with friends, he took it off to use, knew it was a bad idea, was caught a couple days later. His issues have been substance abuse. I think you'll note his record. While he does have a record, it's largely nonviolent. It really is what I call self-destructive crimes. He's been very remorseful and very respectful and engaged in his defense in this matter. I think he's a very thoughtful person, and I think the 214 days that he's been in jail have allowed him to regain his sobriety, the clarity of his thought, the degree to which he participated in his defense. As the time has gone on, I can see the light switching on, if you will. And so what we're asking, Your Honor, is to consider a CBCF program for him, some sort of program where he can go get residential treatment, get himself squared, continue on so that when he gets out, he can get a job, he can progress further as he wants to. He's actually been very sincere and caught up in emotion in terms of the circumstances, and he's had the support of his family, who I think would vouch that if he were given the opportunity, they would support him and be his support community. And I would also offer, if he were sent to CBCF, he stay in contact with me, just so that he's got somebody to talk to. So, Your Honor, he's always considered the ramifications of this charge. He thought that it was necessary to take it to trial because of the question regarding the notion of detention. So he's here taking full accountability. He's remorseful. And we'd ask, Your Honor, to give him a chance to hang on to the sobriety that he's achieved during these 214 days and to move forward.
Mr. Allen, what do you want to tell me?
Yes, in regards to what he was saying, it's true. I've been finding myself to make my situations worse than what they are, putting myself in hazardous situations. And I've been in jail in maximum security for 4 months now, and I've thought about a lot of things. Also, I've been in a law book, obviously. I solely thought that I was not guilty of this crime, and that's the only reason why I took the proceeding the way that I did.
So I don't want to interrupt you, Mr. Allen, but I want to make sure that you understand this clearly. I don't punish people for going to trial. So the fact that we had a trial this morning, there were some questions as to whether or not this specific set of facts fits this specific charge and all that. I don't consider that at all either, for or against you. The fact that we had a trial this morning, I don't hold that against you. So, I don't want to interrupt you, but you don't have to spend a lot of time on that. The fact that we had a trial this morning is not being counted against you.
Yes, sir.
Go ahead.
Like I said, put myself in high-risk situations. I have to change my lifestyle. My lifestyle has played a major part of all the things that's been going on in my life. I've been to prison 6 times. It seems like every time that I go, that I lose a part of me. But I do take full responsibility to everything that I have done. But what I haven't done is take care of the real problem, and that's my drug issue. And I really need to take care of it. And that's all I need to say.
So here's where we're at, Mr. Allen. I get what you're saying about drug problem, being to prison before. We put you on probation, gave you some rules to live by, and it didn't really go that well. So,
Can I say something? Please. Please.
it seems like Mr. Allen doesn't want you to speak, ma'am.
No, I do.
But
I do. I just
who
didn't
is this?
know if
I'm
that's
sorry.
my mother.
I didn't mean to.
That's okay. That's okay.
I just.
All right. Well, let's do this. Mr. Elter, why don't you and Mr. Allen have a seat at council table? Ma'am, why don't you step up to the podium for me? Tell me your name and what it is that you want me to know about this.
Tracy Allen, his mom.
Okay?
If I may say, he's not telling a story when he says he has a real bad issue with drugs. And it seemed like, bad as I want him to come home, I don't. 'Cause I'm afraid he'll do good and then he back out there. And I remember calling his probation officer, whoever it was that was on the case, and I said, do you really think he need to come home with a monitor? I said, because he needs to be in a program, a long-term program. And he thinking, it's hard. I've watched every stage. Every stage. I told his lawyer that, every stage. And I'm his mom, I love him and I support him. But he really does need help. And when you go to jail and you get out, it's supposed to be reformed, but yet they let them out and they're on their own. And then when you get to asking people, it's easy to say, I've never been on drugs. I just know people have, and they'll say, well, you gotta want it, you do, but you gotta keep getting that help that you need. And they'll say, well, we can't help him, we're just here to do this, and he's on probation, and that's it. Now, if he wants help, he can go here and there. It's easy said than done, but I haven't been on it, but I've watched the struggle. I really have. He's not a bad person. He's really not. It's just, it has a hold on him. It really does. That's all I wanted to say.
Okay. Thank you, ma'am.
All right.
So again, Mr. Allen, I get what you're saying. I don't disagree with Mom at all. First of all, just because you're convicted of numerous felony offenses and numerous doesn't make you a bad person. We don't convict people of being bad people. That's not how this goes. You're convicted of a specific crime. The problem that I have is I just can't send you straight to a program based upon your criminal offense, because then I have everybody who I let loose on a monitor is going to cut them off and make a run for it. There is a punishment that is required in this case. The punishment has to be serious, because I have to know that people that I put on these monitors are going to obey the terms of them being on the monitor. So what I'm going to do is I am in the 24 case. I'm going to impose 214 days in jail. I'm going to credit you the 214 days that you have already done. I'm going to shut that part of the case down. In the new case, I'm going to sentence you to 24 months in prison. And you have no jail time credit on that. I'm also going to sentence you to 12 months in prison on the theft charge. I'm going to order that those be served concurrently. That means at the same time as one another. And after a year in prison, if you behave yourself, I will favorably consider you for judicial release into what we call a community-based corrections facility, someplace like STAR or CCC. So willing to break this case into two parts, a punishment part and a treatment part. You have to do your part during the punishment part, stay out of trouble while you're in the institution, do what you can. If you do, then after a year, I will give you the opportunity to go into a program. What a lot of people say to me, though, Mr. Allen, is they do the math on that and be like, I'd just rather serve my time out and not go to the program. That's also fine with me. It doesn't matter to me on that part. But if you do that, that sort of suggests to me that maybe you're not as serious about the treatment as you say, and you're just sort of looking to get out as soon as possible. Because Mom is right, just opening the prison doors and expecting you to be different, that's probably not going to happen without an intervention. But you need to cooperate with that. And when I give you rules to be on a monitor, that kind of stuff, and you cut those off, there has to be a consequence to that. I'm not going to impose a fine. I am going to impose restitution in the amount of $2,099. This 24-month sentence also includes an mandatory period of post-release control. That means if you serve your entire sentence, the adult parole authority can or will supervise you anywhere from 1 to 3 years. If you violate the terms of that supervision, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period. It's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, those will all be provided to you without charge. Whether or not you appeal the case, Mr. Allen, has no effect on whether or not I judicially release you. So if you want to exercise your right to appeal, that's fine with me. I don't take that into account when I am determining whether or not I should place you on judicial release. Really, the only reason that I am considering releasing you back into the community on judicial release is because you have people behind you that care about you. And most of the time when we do these cases, Mr. Allen, it's just me, the defendant, and the lawyers. Nobody has anybody that cares about them enough even to show up, let alone to speak up. So however this comes out when you're done, you need to lean into those people who are behind you because they want you to succeed far more than I do. All right, anything else? Anything I forgot?
No, Your Honor, thank you.
All right, good luck to you, Mr. Allen. You do have 30 days from the filing of the judgment entry of sentence to appeal as a matter of right. I anticipate that that's going to be today. If you want to file a notice of appeal, let Mr. Elter know that. He will appeal the case for you, but he will not be your lawyer for the purposes of appeal. All right, that's all.